Thank you, Mr. Chair. I appreciate this brief moment. Ladies and gentlemen, I just wanted to give a quick introduction of my family that's going to be joining me today. Although some of them have been around, I don't think they've sat in on this committee. My oldest brother from Savannah, Georgia, Larry Simmons. My daughter, Sanaya, who turns 16 on Wednesday. And my son, Quentin, who's my little twin. We're both Leos. Yeah.
And now that that's out of the way, we're all done. We can all go. This is the House Judiciary Committee. It's Monday, the 3rd of April. We've got House Bill 208 to start. We have Delegate Love from the Environment and Transportation Committee who's here, and counsel from ENT. Would you like to say a couple words about the bill generally right now? Or that I know that a lot of members of the committee had questions for counsel too, so I'll go in whatever order.
Mr. Chair, if you would like to just dive in, we're good. Thank you.
All right, that's fine. When we last left our story here, there seemed to be a lot of questions that were going around that seemed to be relevant to counsel for ENT. So I'm happy to. Now no one's lighting up their microphones, so of course now that he's here.
Move favorable.
That's fine. Here's Delegate Crutchfield to begin.
Thank you, Mr. Chair. And how are you doing?
I'm well, thank you.
So, there's been a lot of, information around this particular bill, specifically dealing with Ocean City and wanting to possibly exclude that from this bill. So kind of tell us really, like in a quick summary, what's the real differences between what we have before us with amendments versus what the Ocean City bill was, or Worcester County, or whatever format that bill was in?
Sure. And if you don't mind, I'm going to take a couple of steps back. So Ocean City came to the legislature in 2020 because they were having a lot of problems with this behavior that we have now come to call exhibition driving. And we passed the Ocean City law during COVID. Years later, in looking at it, we realized that it needs some tightening up. And we want to pass something statewide because the behavior that was only in Ocean City is now statewide. So we took the core of what they have and we've added to it. And now I will get to the exact answer. So under the definition of exhibition driving, we've added in close proximity to a crowd or gathering. That was not in the Ocean City law. And then it goes on to state in a matter that, and we added the word intentionally, and then we added, then it goes on, results in, and we added two or more of the following. And then the only other thing that we did is we took what used to be, subsection 1 had a list of things, 1 through 6, and then there was a subsection 2 that talked about driving with somebody on the hood of the car. And we made that number 7. So it's just one list of things that a driver must do 2. I will tell the committee I had a very long conversation with the mayor of Ocean City. We had a very pleasant conversation. The mayor understands my position. I understand the mayor's position. But what I said to the mayor was everything that happened in Ocean City, every behavior can still be charged as we have redrafted this law, this bill. And I walked through the behavior, the donuts, all of it. And the mayor is still understandably concerned because they don't want any change. They're afraid of what would happen. But I am absolutely confident that, and I had an intern Google everything and just to be sure, that the same behavior that happened in Ocean City that we are seeing around the state can still be done under this law. But the main changes are 2 or more of the following, around a crowd, and intentional.
Okay. Mr. Chair, one more question. So it appears with that amendment, though, you're narrowing things down a bit. So I'm thinking about situations in neighborhoods where this happens, you know, because now you're adding in that this truly has to have an audience space, whereas the original bill with Worcester County, Ocean City did not provide that. But you're saying that you do believe that this bill will also be able to be valuable in those situations as well? Can you kind of tell us a little bit more about that?
Sure. I mean, the whole point of these car meetups is to draw a crowd, and all of them have crowds. Now, there has been some conversation about people doing extremely loud things in a neighborhood. Well, that may not be what we want to term exhibition driving. So there are different ways to go at different behaviors. So I'm not sure when you say in a neighborhood what you're talking about, but when we're talking about something that we're defining here as exhibition driving, you know, doing these donuts. I don't know if you all got to see the videos that we have seen. I mean, people are squealing, they're burning the tires, people are hanging out, there are hundreds of people watching. That's the kind of behavior that we want to get at with this law and with these very strict penalties. I mean, if somebody is making noise in a neighborhood, you know, you're kind of being a jerk, but I don't know that your car should be impounded. But that behavior might fall under something else. So if you have something specific, then I'm happy to answer that directly.
Okay. Yeah, more of maybe the drag racing, not so much the donutting, you know, but in neighborhoods. In fact, I heard it over the weekend in my neighborhood, you know, the sounds of people, you know, definitely there were 2 or more cars going up a small, narrow road, but doing it very fast. I don't know if it would even, like you mentioned, be within the bounds of that, but it certainly is a nuisance by all means, and appears to be something similar to that. So that's kind of what I'm talking about. You know, sure. There are neighborhoods where maybe it's not such a long pathway as far as the driving goes, but it still has those kinds of consequences of, you know, 2 or more people that are driving, and it may not attract necessarily a crowd, but it certainly, neighbors may hear it, you know. Sure. So again, like you said, it may not fall within those bounds, but it certainly is something, you know, I think that most of us are probably dealing with.
Sure. So a couple of things with that. Just to be clear, it doesn't have to be 2 or more cars.
Right.
It has to
Understood.
be 2 or more of the instances. Right. What you just said, the intentional acceleration and the noise, that would fall under 2 of these. And it could be a crowd or a gathering. So, you know, it doesn't have to be 300 people. It could be, you know, a handful of folks. On top of that, though, there is, and I'm going to turn it over to counsel, drag racing is illegal in the state.
That is correct. That is a current violation in the code. The exhibition driving that Delegate Love has been describing is a new violation under the bill.
Okay. Thank you. Mm-hmm.
And the penalties mirror each other in the bill.
Go to the Vice Chair, then Delegate Tomlinson, Delegate Phillips, Delegate Grammer. I see Delegate Kaufman.
Thank you, Mr. Chair. You may have just answered my question, but I was actually going to ask about the penalty component here. My recollection was when Ocean City got the other bill put in, that I thought it was not incarcerable, but it was an impounding. It was a method to impound that lacked incarceration. The last go-round, we had this bill, and it looks like that's changed in this go-round. And I gather part of this is because of the AG advice that you can't impound without an incarcerable offense or something like this. Could you just elaborate on the penalty provisions?
Yeah. Last year's legislation that passed and was vetoed did not have incarceration. The House took that out and came to realize, in dealing with this over the interim, that the incarceration was needed to get to the impoundment. Without the incarceration, which basically consists of 1 night, overnight, or even release of recognizance, that they could not impound the car. And that is the big hammer here.
And so just to follow this, because I am now sensitive and I see Ocean City's folks are in the audience, does this mean to suggest that what Ocean City is doing, impounding vehicles without an incarcerable offense, is legally suspect?
I don't have the Ocean City statute right in front of me, but I believe the Ocean City statute has incarceration. I'd have to check on that, Delegate.
Even though the state statute does not.
We don't have a current state statute. So
it
we
was
had a
vetoed.
bill
It's
last
not in the
year.
bill.
Yeah, okay,
So
I see.
Ocean City does have incarceration, to the best of my knowledge. But the bill that we had last year that was vetoed by the governor did not.
Okay. All right, thank you.
And my understanding, one of the reasons it was vetoed by the governor was it had 2 or more cars had to do that. And that Ocean City was very unhappy about.
Okay, but so just so I'm crystal clear on this, you believe that it is not legal for us to authorize impounding unless there's incarceration?
Yes, basically, the car has to be, because if you arrest somebody and the car's sitting there on the side of the road, they'll impound it. You can't impound just because they get a ticket.
Okay, all right, thank you.
Delegate Tomlinson, then Phillips, then Grammer, then Kaufman. I think I got that right, but did I go over there first? And I missed, okay, I'm going to add Embry, but let's go to Tomlinson and then.
She might have been before me, but
I couldn't see her light from here.
Okay.
I'll add Embry and enrage everyone else after Tomlinson, so that's fine.
thanks. I tried. Thank you, Chairman. So it seems like the bill, I mean, obviously the bill is well-intended, and it's definitely going to help address exhibition driving across the state. But it sounds like for Ocean City, it's going to be taking them backwards because this bill is a little more restrictive than what was passed a few years back that just applied to Worcester County, which kind of cast a larger net, no pun intended. I mean, has there been any talk about, since everything since it seems like most of the issues surrounding what is now the current version of the bill out of ENT has to do with Ocean City, I mean, has there been any talk of just kind of carving Worcester County out of the bill?
Thank you for the question. We did talk about that, but for 2 reasons, that doesn't make sense. One, to have 2 different definitions of exhibition driving in the law doesn't make sense. It just gets things very, very confusing. And number 2, the way we passed that bill originally is problematic because it says you can be arrested and lose your car for the excessive abrupt acceleration of a motor vehicle or the excessive abrupt deceleration of a motor vehicle. So I'm heading towards an intersection and a little kid runs into the road, I slam on my brakes, that's exhibition driving under the letter of the law. It also says that exhibition driving is the transportation of a passenger on or in an area of a motor vehicle that is not designed or intended for a passenger transport, such as the hood or a roof. So a parade. Or, when I was young, I would sit on the car and my sister would drive me down the driveway. So I don't know if, young idiots still do that in, private areas, but under the law, that's exhibition driving. So we couldn't adopt that statewide, and it's very concerning as a definition because it's incredibly broad.
Okay, so there is no interest in amending it to exclude Worcester County?
No, because that really would be very confusing and unfair to drivers because you wouldn't know. And then you're going to have a problem because somebody, are you in Worcester County? Are you not in Worcester County? It would just get too confusing for law enforcement and for drivers.
Okay, thank you.
The first is crowd defined anywhere in the transportation article? And
Not to my knowledge.
should it be defined? Is it more than 2 people?
I think it's relatively well understood what crowd or gathering is.
More, but if the police are counting people, well, all right. Is it 2 or more people? Is it 2 or more people? Is it 5 or more people? 50 or more people?
I would think it would be people paying attention, watching. I mean, you see these videos, it's pretty obvious that these are crowds.
Okay. And the second question is, I just don't know impoundment law. If the state law provides for impoundment, is what happens to the car governed by local law in every jurisdiction, or is there in the transportation code direction for impoundment? I know there is for DUIs, but I think that's specific.
That's an excellent question. We actually have, I do not know if the committee has this. I will provide it if they do. There's a Attorney General's letter of advice on this issue. It's actually not local law, it's constitutional law. We can put impoundment in every code we want. It's still subject to the Fourth Amendment. Well, the essence is that, like we said earlier, a police officer can't just write you a ticket for speeding and have your car impounded. That would be an illegal seizure. But if you are arrested for something and the car is on the side of the road, that's a hazard, and they are allowed to impound it. And of course, they have to give it back to you after you pay the impoundment fee. But it's in the, I have the opinion right here. It's called the community caretaking provision. That, you know, if the car's stolen, of course, then they can impound it.
Right. Or in a
things
note.
like that. But they can't just take your car.
But if it is, so we've authorized it, in terms of the procedure of someone getting the car back, what governs that procedure?
Well, that would be local law.
Okay. Thank you very much.
Was there any conversation with Worcester County about their enforcement of the current law and how the proposed law would have impacted their enforcement? In other words, with these changes, were there things that they may not have been able to do if what we're proposing was the law in 2020? Has anybody done that analysis?
I talked to the mayor, and we went through the behaviors of the drivers. And like I said, everything that I talked about with the mayor, everything that I have been able to find in my research and my intern's research is still covered under this bill.
So that, and I understand what you're saying. Maybe I'm asking the question differently.
Okay.
I'm saying they've used this law, they've prosecuted individuals. Has anybody looked at those individuals that were that were prosecuted under this or whatever, and compared that to what is proposed? You know, just even if it was just a few cases, has anybody actually looked at those to see if they would still have been prosecutable under what is proposed? I know, I hear what you're saying. You're saying the behaviors, but I'm talking about facts, because all these things turn on facts.
Right. I guess I'm unclear the difference of the two. We're talking about the behaviors that drivers do that they were arrested for. That behavior is covered under this. And,
Okay.
and the mayor and I talked about that, and I fully understand the mayor's concern. But everything that I've heard from, researched, and been able to find out is that all of those prosecutions could still happen under the law. If one of them wouldn't have been able to, that is not something that the mayor shared with me. And that's not what I have been able to find.
Okay. And I was the second question, like the vice chair, I am concerned about criminalizing folks for the purpose of impounding the vehicle. If I am driving with an invalid license or registration, a car can be impounded, right? If I violate a law that is on the books, then a car can be impounded, similar to driving without a license or a bad registration. So shouldn't I be able to devise a penalty that would pass the Constitution that would say if you violate this, a car can be impounded? Shouldn't we be able to do that short of having to incarcerate a person?
I think I'll start with an answer that's not direct, and then hand that over to council. Delegate, the behavior that we're talking about is incredibly dangerous. People have been hit, people have been killed. This is not just, somebody in a parking lot by themselves doing donuts. This is crowds of people and tremendously intentional, dangerous, deadly behavior. So as a former ACLU lobbyist, where I spend a lot of my time at this exact table, I think they should be incarcerated. But as to the direct question, counsel?
Not really, because, like I said, we can put impoundment into any statute we want, and it's still subject to the Fourth Amendment. Like I said, if you get pulled over for speeding, which is not incarcerable, they will write you a ticket. They cannot arrest you unless there's another charge, and they cannot take your car. So that's why, and it's intentionally a low amount of incarceration, but that's what it's in there for, is to get to the impoundment.
But once again, I can devise a statute that says, under these circumstances, I can impound your vehicle.
I don't know how you would do that here. This is not how we drafted it, because we couldn't find a way, I guess.
Okay, thank you.
Delegates Grammer, then Kaufman, then Pasteur.
Thank you, Mr. Chair. So while I have questions about qualifying 2 or more of these activities, I think those are just questions. What I think I have a real problem with is the in close proximity to a crowd or gathering. So this is how, and my Baltimore City folks will remember this, here's how the story goes. Exhibition drivers are on Key Highway. Exhibition drivers are on Light Street. Now they're at the Inner Harbor. Now they're at my favorite intersection, Dundalk and Holabird. They don't show up with a crowd or gathering. They show up, sometimes a crowd or gathering follows or manifests. But for me, the activity, whether it's 200 people or 2 people, the activity is the activity. And if one person gets run over and killed, why is this suddenly not an offense if we don't have a crowd or gathering?
So the thought behind that was that the true exhibition driving is they want to do this in front of a crowd. That's the whole point of it, is they're bringing a crowd. And there is a difference between one person in a parking lot doing donuts by themselves and doing it around a crowd.
Not
if you're
if
doing
it's your
donuts
kid
by
that gets run
yourself
over.
in a parking lot, you may be an idiot, but you're not putting anybody else in danger. If you are with a crowd or gathering, and I would suggest that a gathering doesn't have to be a huge number of people. That's the difference between crowd and gathering.
If I'm in Costco, I'm coming out of Costco, and my kid gets run over by some guy doing donuts, why do I need a gathering? Why is the activity still not the activity? It's still just as stupid. It's still just as dangerous. Why is my relief dependent on having a crowd?
That driver is going to be convicted for vehicular homicide. You don't need exhibition driving for that.
What if you got them on videotape? What if it's 2 people? What if they're doing the same exact thing, but you can't follow through with it because, well, there wasn't a crowd, so, they don't get the points.
So I guess the is what matters, because we have reckless driving, we have negligent driving. This is a special subset to target specific behavior. We have drag racing. So it really matters, because these other things can be addressed through other laws. But there is a very specific issue that we are addressing right now, and these are in crowds.
But they do move. They move.
Sure.
At least in relation to my district, and I'd say parts of the region, they just bounce around. They move. And I don't get why, if you follow the same 3 or 4 cars all the way around the water, and you can get them in one place via camera, you get all 4 license plates, and you say, well, it's clearly the same 4 cars, but at here where we got them on a license plate, they didn't have a crowd there. I don't get that. I kind of understand where you're coming from, but I'm fine with the rest of the bill. I just don't see a need for why that's there, and that's just me personally. Thank you.
Delegates Kaufman and Pester, and that'll be the last word. Delegate Kaufman.
Yes, Mr. Chair, I will be brief because we have a 4-page voting list, but I do want to ask Delegate Love a question. Earlier this morning, the lobbyists from Ocean City sent all the members of the committee an email because, and so I was just wondering if you had any comment with regard to that, because it was shared with you, and I'm obviously not able to drag race, so this issue is a little bit confusing for me, and the email today added some confusion for me. So if you could enlighten me in terms of your perspective of the email.
Sure. The concerns were with the new language that we have put in. Most of what we have discussed here, close proximity to a crowd, we talked about. Now, the instance that they brought up, the person who infamously did donuts on the Bay Bridge, that person was stopping traffic. Okay, those cars are your crowd or gathering, so that could be charged under this bill. So that first paragraph, it's the example that they used, it would not be a problem. Intentionally, they're concerned about the word intentionally raising another issue that has to be proved in court. This is the sort of thing where your actions prove your intent. It's very clear that if somebody is doing these behaviors, they are doing so intentionally, not accidentally. 2 or more of the following, we've talked about that. That was another one of their concerns. And like I said, I've gone through all of the things that I've been able to find about the behavior that happened in Ocean City, about the behavior that happened not this last weekend, but the weekend before, in Prince George's County, Howard County, Anne Arundel County, and Baltimore County. They're all 2 or more. And I'll just end with my original concern about this statute and how broad it is, and that we do not want to be arresting people and taking their cars if they slam on their brakes for a child or a deer or something else like that.
Thank you, Delegate. Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chair. So I need to go back just for a moment on the crowd situation. You were asked if there's a definition. There is none. And then I think you said it's pretty much understood what is meant by a crowd. So what happens, or does this apply if, and I'm going to use the word intentional, if the crowd is not intentional? It's an unintentional crowd because where the people are, maybe it is in a shopping center where they decide to do this. And I'm going to just use an example of one that I witnessed, and I admit I started screaming, and I probably could have had my own accident because I was screaming. As the cars, and this was on Route 50, before getting to Ocean City, the cars were speeding down on the right side because everybody on the left side is trying to go to the outlet mall that's on 50. And so they were doing all manner of tricks on 50 in the summertime. Can you picture that? That's not pretty. And then cut across the lanes at that light going to the outlet mall. See how I vividly remember this? And turned into that outlet mall where they were doing all manner of things while people were coming or going in and out of stores, and there was a tour bus, and the people were getting off the bus and getting on the bus, and all of that was happening. So there were whatever the stop signs were, obviously they were not paying attention, and people were still moving. So the crowd became, as I'm calling it, unintentional. So they stopped and they looked. So I'm going to use that. That's in Ocean City. Where I live used to have all sorts of winding roads and hills and things, and so folks used to do that all the time. when the development came, they still continued to do it, even though there were no hills and all of that. But it's great streets and hills. So the neighbors come out and have complained. Again, it's an unintentional crowd. So what I want to know is, does this hold any fodder whatsoever in that situation, or do you call it something else? Because it's dangerous no matter how you look at it. What they were doing was intentional. The missing piece is calling it, and now I'm going to call it, the intentional crowd. Can you help me with that in terms of the bill?
Well, the prohibited act in the bill goes to the driver, not the crowd. So if the crowd is intentional or unintentional, I would still think there would be a violation.
So would someone have to explain that, because this just says in terms of the driving, that it is intentional, but again, the question about the crowd or gathering, it's maybe more than the word crowd, it's the word gathering that is of concern. So if the gathering is unintentional, because everything that you've said up till now is that the crowd will follow it or there's a crowd, I want to know if is this going to hold mustard if it is intentionally done, but the crowd is different from what has been described up to this point.
Yes, is the short answer. The way it is written, the operation of a motor vehicle in close proximity to a crowd or gathering in a manner that intentionally results in two or more of the following. So the intentional follows the driver doing those actions, not the crowd.
So I can tell the little old people
Yes, ma'am.
in my community, it's about the driver.
We are on the bill as amended. It was amended at our previous vote session to reflect the amendments that were adopted by the Environment and Transportation Committee. There's a motion for a favorable and a second. I think we've had plenty of discussion now on this. And I think we're ready to go. With that, I'm sorry. All right, Delegate Taylor with a burning question.
I do, because
All right.
I have family members that have really nice cars, like sporty cars, and they have car clubs. And they travel 30, 40 at a time from Prince George's County to other places in the state. And then they stop somewhere, they all park, and they get out, and they look at each other's cars. I'm looking at the definition of exhibition driving here, and I think this is the new definition that says two of these things, and I'm finding two of these things that may occur in these, in these instances during these events, and that is the engine of the motor vehicle producing an unreasonably loud, raucous, or disturbing noise. Well, they intentionally put things in their cars, on their motors, that make them loud. So that's one thing. And then the second thing is the grinding of the gears of the motor vehicle or the backfiring of the engine of the motor vehicle. I happen to know that there's something else that they do to the engines now that have them, what my son calls spitting. It's like this backfiring noise. But they're just sitting. They're not causing any problems. But under this law, this new law, would they be prosecuted and their vehicles be impounded?
In my reading of the bill, and counsel maybe can help me, because again, this goes, the first words are the operation of a motor vehicle. So it requires the operation of a motor vehicle. If a motor vehicle was sitting in one place and they were revving the engine, it would be one thing, I think. But that would be an open question under, I guess, Atkinson as to whether or not that would be under operation. But counsel?
I think I'd have to look close at the definition of operation. I know that is a defined term. I do not believe that, I believe you have to be moving under the statute, though. I could get that answer for you. I'd be glad to. One thing I will say is that, believe it or not, these car clubs are well organized, and they have not come out in opposition to this.
go a little further. Delegate Erican.
Thanks. I think maybe two things. I think operation just means the car turned on. I can't remember, but I know we've had bills in the past where we've touched on that. So I think that that's true. But I also think in these situations, usually they actually have the spaces reserved. So when they go to a location, they actually ask permission first. I just don't know if this would really trigger a situation. And I think that's probably why the car clubs haven't come out, because they already know that they're reserving those spaces and they're advertising usually, in legitimate situations in advance. But also, I thought it might help illuminate the discussion for the chair to just sort of explain legislative intent and us having this conversation and us talking about what the intent of the bill is, and you guys actually being present could actually be introduced into a court case. So maybe he could touch on that so that people who don't understand what that is would understand it better.
I mean, if it helps, I mean, just to underline, yeah, I think the goal here is to stop people from actually, the sponsor's clear intent, as I read it, is that it is a car in motion that could potentially hit someone else. That's the whole point behind having a crowd there. And so to that end, I believe that is clear, that the vehicle has to be in operation. And I don't believe that it would apply to a car club where the cars are sitting there. However, a car could rev up and could make those sounds and do all of those things. But I don't believe that in that situation, the car is in park. I don't believe that you would say that the car is in operation. Where that word is used more commonly is in DUIs, where you have somebody who's on the side of the road who is there's basically not quite an exemption, but exemptions, I guess, probably the right word. If they're on the side of the road, it's a cold night, they are in the passenger seat of the car lying down. They may be inebriated, but they've got the car running just to stay warm as opposed to running because it's driving down the roadway. I think that's the distinction with the definition of operating. Delegate Williams.
Yes, in my free time just now, I decided to pull the transportation article. And it says, operate as used in reference to a vehicle means to drive as defined in this subtitle. So it sounds like the car has to be moving.
Leave it to me to start wheeling drunk driving into it. But anyway, okay. Are there further questions? Otherwise, the Vice Chair.
Yes, and can I just quickly explain my vote?
Yes, go ahead.
The bill this year does have jail. The bill last year did not, but I will note a couple things. Crowd requirement is new. And I guess you're saying this is the same penalty as drag racing, so with that, I'm a yes.
Delegate. Yes. Delegate Crutchfield. Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes, and you can explain your vote.
Thank you so much. I do have some concern about it being a jailable offense, as well as what the Vice Chair indicated, and because it speaks to a crowd. And obviously, I'm concerned about, how black folks being in a crowd and being a jailable offense could, depending on who or what the situation is, it could be problematic, and it could be somewhat of a racial issue. So I just hope that we are monitoring this in the years to come to ensure you don't have those issues, particularly with black people. So with that, I'll vote yes, and watching what happens. Thank you, Mr.
Delegate Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes.
So I'm still worried about the crowd piece, specifically because if Baltimore City has the center where all the cameras are, and they see somebody that's doing these and there's nobody there, and maybe they do it for the purpose of creating a TikTok video. I would want the city to be able to prosecute that person. And I think the crowd piece may preclude them from doing it. But I still support the bill. I think that's a conversation we can have on a larger scale later on. Thank you, Mr. Chair.
Thank you. Valentine? No. Conaway? No. Kaufman? Yes. Yes. Williams? Yes. Motion is adopted. Thank you all very much. Thanks to the people who have come and visited us from the Environment and Transportation Committee, who will never come back again. Or who can say? Maybe. All right. House Bill 233, slightly different issue now. This legislation has an amendment that is being offered by the chair. One of the questions that has come up as there's been discussion on this bill, and there's been some discussion on this bill, is the question about inadvertent viewing, and I'll be honest, kind of gone round and round and round with this quite a bit. But the committee should have an amendment in their packets. Is that right, Dylan? They've got this amendment, and that would do the following. There was some conversation about adding the word prurient to Section B of the child pornography statute, and the concern that was expressed by some people was that by adding that there, you impact not only the streaming, but you also impact the possession of actual films and videotapes. The goal of the legislation is to get at streaming and to address that issue. And so I felt that it made more sense to create a second section that reads, "A person may not knowingly or intentionally access or intentionally view a film, videotape, photograph, or other visual representation showing an actual child or computer-generated image that is indistinguishable from an actual and identifiable child under the age of 16 years of age." I think it addresses the issue, and it takes out hopefully takes out the confusion here. But what I'd like to do right now is move the amendment and take a second, and then we'll take discussion on the amendment. Delegate Bartlett, and then Eric.
When you read it, you did it a little differently. And you used the word "or" under "a person may not knowingly or intentionally access or intentionally view" for Section 2. Do we want "or" "and"?
I should have said "and."
Okay. All right, just wanted to make sure.
Sorry. It happens. Delegate Erican, please.
What was the decision on under 16? What's our current, doesn't our current law apply to 17 and 16-year-olds as well?
No, the current law is 16 and up.
Oh, it is? Okay.
Yeah,
All right,
so
thanks.
that doesn't change anything. Literally doesn't change anything, except it's basically creating a separate section just for
streaming,
for viewing.
Right.
So seeking again to go to the streaming aspect of it as opposed to the actual possession of a physical thing.
Okay.
Part of it.
Awesome. Thanks.
Delegate Conaway.
Thank you, Mr. Chairman. So what you're proposing now is that a person cannot view something that's computer generated, something that's fantasy fiction? Is that what we're proposing?
That's existing law. That's existing law, and that's taken from the current statute. So we took that and
just because this is existing doesn't mean that it's correct. I would like to say that. Thank you.
Thank you. Are there other questions? Delegate Young.
Is one. Thank you. with artificial intelligence creating these images with like text prompts, I imagine that might be a conversation we should reconsider having in the near term, or whenever it's appropriate, I should say, Mr. Chair.
No, and look, this is part of the reason that this seems like it should be self-evident, that you should not, that, not a lot of experience with this, but having said that, people stream things all the time. People are streaming video all the time. We do in any number of different platforms in any number of different ways. But the concern is, here's a link that says, click here and get $1,000. You should never click on that anyway, probably, but let's just say you click on this and it leads you to that page. You're not intentionally going to look at child pornography. You're clicking because you think it's something else, and you're being taken in that direction. And so the goal is to not catch those people in sort of a jackpot of, well, you got tricked by somebody else, and then you have that issue. As far as what's going on with AI, that is a much larger issue. It is a much, much larger issue that we're going to have to confront here, I think, in the committee over the next couple years. Not, sadly, in the next 7 days, but certainly in the next couple years. And I look forward to everyone getting on a work group about that.
Thank you, Mr. Chair.
No, I'm not setting up another work group. Are there other questions about the amendment? And there's a motion and a second on the amendment. All in favor of the amendment, raise your hands, please. Is there anyone opposed to the amendment? No one is opposed to the amendment. There's a motion for a favorable as amended and a second. All right. Any further discussion on the bill as amended? Seeing none. The Vice Chair? Yes. Yes. Munoz? Yes. Crutchfield? Yes. Cardin is excused. Bartlett? Yes.
I'm voting yes, a strong yes on this bill because there are provisions under Section E for affirmative defense. So if you take reasonable steps to destroy it, or if you report it. So if you see it, and you're not supposed to, and you didn't intend to see it, and you delete it, or get rid of it, or do whatever you need to do, you have that affirmative defense. So I think that all matters have been taken into consideration, and we have to protect our children under 16, if not beyond that. Thank you very much, Mr. Chair.
Delegate Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? We can add on because it's an amendment, so before I go any further, do you want to? No? Yes. Add on to Munoz, Crutchfield? No. Bartlett? Yes. Yes. Add on Embry? Yes. Pasteur? Yes. Tolles? No. Okay. Simmons? Boucher? Yes. Phillips? Yes, an add-on? Sure. Okay. Tomlinson? Yes. Erican? Yes, an add-on. Taylor? Yes. Simpson? Yes, an add-on. Grammer? You have to cast it first. What would your vote be? Yes? Okay. Go ahead.
It is not.
Yes. Valentine? Yes, an add-on. Conaway? Yes. Kaufman? Yes, an add-on. Williams? Yes. All right, motion is adopted. Delegate Phillips, did you have a
Bartlett just really created this question for me. In that E, it says, took reasonable steps to destroy each visual representation. We're talking about streaming. Do you destroy streaming?
I don't think you could destroy the streaming. You would want to demonstrate that you had closed the window quickly. I think that's as close to a destruction as you would be able to get in that place. Look, again, the questions here have to do with issues of technology and how you address that. It's imperfect, and that's going to be part of the problem going forward here as we try to catch up with the technology. Okay. Then there's that one. So I'm giving that to you. Okay, we're not going to be able to do 4:30 just yet. I'm still trying to figure that out. And then we've got Senate Bill 5, which is the cross file of Senator Kramer, Delegate Crutchfield's bill. Oy. There are no amendments. It's a motion for a favorable and a second. Any questions or comments on Senate Bill 5? Seeing none, it's a straight favorable. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? No. Senate Bill 5. Arakan? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Motion is adopted. Okay, we have to hold off on Senate Bills 37 and House Bill 97 for a beat. We will come back in an upcoming vote session, but for now, we're going to hold on to those two for a moment and go to Senate Bill 42, which is Senator Carter's bill. There's a motion for a favorable. Is there a second? Second. This is cross-filed with who? Delegate Nick Charles, right. This was for something? House Bill 440, all right. Yeah, there's motion and a second for a favorable. Is there further discussion on this bill? All right. So, Delegate Young.
Didn't we amend Delegate Charles's bill? And is this in the same posture?
They're the same.
They started out on the Senate side with the amendments.
Right. So we took their amendments, passed it as amended, and now we're taking their clean Senate bill. It's not that they were right, it's that we agree with them. All right. Are there any questions at all? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles?
Yes, and I wanted to, thank you, Mr. Chair. I wanted to just publicly congratulate my teammate in District 25. I know this was a personal, this was a true constituent issue that he brought last year as a delegate, and to see that it's coming back this year and passing out. I just want to say that's what we do here as doing the work of the people, and they have a real issue. So knowing the personal story behind this, I'm happy to see it's moving forward this year. So thank you, Mr. Chair.
All right, thank you. Delegate Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Arakan? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Motion is adopted. Okie dokie. Gonna go now to Senate Bill 67. There's a motion for a favorable and a second, couple seconds. This was not cross-filed, if memory serves, correct, Holly? Yes. Right, so this is first impression to us. Can we just have the brief overview, please, about what this bill does? Because we're bill of first impression. Not really first impression, but it's a bill of that we didn't hear before.
So, Senate Bill 67, the bill just changes the duties of the clerk of the court. So right now, under the court's article, a clerk has to report to the secretary the name and office of each officer who's taken an oath for commission. This changes it from once a month to regularly. And then the bill repeals obsolete requirements with regard to prohibiting a court from administering the oath and specifying dates the clerk must pay the treasurer, which aren't necessary anymore. It passed out of the Senate and 46-0.
All right. Any questions at all? Seeing none, thank you. We're on the favorable motion. The Vice Chair? Yes. Yes. Munoz? Yes. Crutchfield? Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? All right. Excused. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. Okay. Senate Bill 6.
Second.
And now I will call Senate Bill 99. There's a motion for a favorable and a second. Good Lord. All right. And it's only Monday. Is there further discussion on Senate Bill 99? Seeing none. Again, we're passing a clean cross-file. The Vice Chair? Yes. Yes. Munoz? Yes. Yes. Crutchfield? Yes. Yes. Bartlett? Yes. Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Is excused. Kaufman?
Yes.
Yes. Williams?
Yes.
Yes. All right. That is Senate Bill 99. Senate Bill 100 is the cross-file of House Bill 36, where there is alleged peace in the valley between everybody, but we've been here before, so, you know, it'll be fun to find out. But we're amending, if I'm not mistaken, where'd Holly go? We're not amending. No amendments.
It matches the Senate.
It matches the Senate bill, and we're moving favorable, and we passed it clean. We're passing it the same way that we passed it. Great. Further discussion on the bill as amended? Seeing none. The Vice Chair? Yes. Munoz? No. No. Crutchfield? Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. I see 14. Motion is adopted. All right, now the cross-file of another of Delegate Crutchfield's bills. This is Senator Jackson's Bill 115, and it is without an amendment. It's a motion for a favorable and a second. Is there further discussion on Senate Bill 115? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Motion is adopted. So quiet in here otherwise, it's kind of weird. All right. Now we have something that's been amended. Senate Bill 173. There is an amendment. Is this you? This is Claire again. Claire. What does the amendment do, Claire?
It's just technical, and Senator Waldstreicher agreed to it, or said, please do it.
He did in the middle of the hearing, I think. He took the technical amendment, if I'm not mistaken. All right, so there's a technical amendment. There's a motion for the technical amendment and a second. Is there discussion on the amendment? Seeing none. All in favor of the amendment, raise your hands. Anybody opposed to the technical amendment? Delegate Simpson's team appears to have left her hand up too long, but okay, fine. We're on the bill as amended. The amendment was adopted. We're on the bill as amended. Can I have a motion? There's a motion for a favorable and a second. All right, is there any further discussion on the bill as amended? Seeing none. The Vice Chair? Yes. Munoz? No. Crutchfield? Yes. Cardin is excused. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion is adopted. Okay. Keep going. Senate Bill 185. Motion for a favorable and a second. There are no amendments. This is the cross-file Delegate Bartlett's bill. All right. Oh, that's right, HB 3. Three, I tell you, 3. Are there further, is there any discussion with regard to Senate Bill 185? Senator Delegate Bartlett believes it's a great bill, but it's sponsored by her senator, so who can say? She sat there during this hearing and said that you were her favorite delegate. That's what she did. She implied it. She implied it. You're very... Vice Chair Chang was very upset when he heard about that. And Delegate Rogers. Anyway, I'm going to stop now. We'll go to, seeing no discussion, the Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin is excused. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. No. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. The motion is adopted. Okay. Prince George's County, Senate Bill 191. What do you think?
Do we have the letter from the delegation?
Do we have the letter? Oh, we may not have the letter
I
yet.
think we have to hold this.
I don't think that they have the letter. I think we only heard it last week, and you all didn't turn it around. All right,
I don't think we sent the letter.
we're gonna hold on 191 because we don't have the letter yet, and that is remarkably important. So we need to do that. So put that in stack number 2. We'll go to another of Holly's bills, Senate Bill 253. And this is a cross-file of a 244. Is that Cardin's bill? Yeah. Okay. Remember some things, I guess. All right. So this is a. Oh yes, it was Delegate Terras's bill, actually. Well, completely wrong. All right. Fine. Is there a motion and a second? Great. So we're on the motion for a favorable with a second. Is there discussion on this bill? Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin is excused. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway is excused. Kaufman. Yes. Williams. Motion is adopted. Okay, now we are on Senator Kagan's anti-swatting bill. There are no amendments. We passed it, the motion for a favorable in a second. We passed it in this, I believe, we didn't pass it in this, whose is this? Is this passed in the same way as we passed it, or it's different?
Takes out the emotional distress.
It takes out the emotional distress part of it? Okay, and I believe that the sponsors on both sides were okay with that. All right. Is this your bill? Nicole, is this your bill? Delegate Williams, sorry, oops. Okay, can I have a motion for a favorable? Is there a second? All right, motion for a favorable in a second. Now, are there questions as to this bill?
Yeah.
Delegate Erica.
Thanks. Could you just talk me through what the removal means practically?
Could we bring, Claire, can you come, or who wants to? Delegate Williams, can you speak to that?
Yeah, I think it just removes emotional distress as a cause of action in terms of the penalties under the bill, is what the Senate did. They amended the bill on their side, and so that's how it came over to us.
Okay, I understand. All right, thank you.
Any further questions on the bill? I have a motion and a second. All right, the Vice Chair. Yes. Munoz? Yes. Yes. Crutchfield? Yes. Yes. Cardin is excused. Still. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Mostly yes. Schmidt? All right. 125% of a yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. All right. I'm going to put everybody on notice. I think we're going to stop at 2:30 because we're going to give some people some time. The floor session will go long. So I'm just giving people a heads up that we're expecting a long night tonight. So we're going to let people get out of here and get where you need to be. I'm going to go for a little while longer, and then I need to stop. Yes, Delegate Kaufman.
So members should expect a voting session after floor then? Because we're not going to get through all of it today.
No, you should not expect a voting session after floor, definite voting session tomorrow after the bill hearings. Yeah, you can expect bill hearings a lot over the next 7 days. But a voting session, you can expect bill hearings too on Tuesday, Wednesday, and Thursday. Or is it just Tuesday and Wednesday? Tuesday and Wednesday. But that's kind of where we are right now with this time of session. So let's do 342. And on time is John Carden.
Move favorable.
Motion for a favorable in a second. Senate Bill 342 that adds a circuit court judgeship in Baltimore County. I'm enjoying the joke. I don't know. Having said that, what's your discussion? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Carden? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? All right, we're going to do one more, and then I think we're done. The motion's adopted on 342. Actually, we're going to do two more and get both of these out of here. Maybe just one. I don't know. Senate Bill 351, which appears to have somehow resolved its fiscal problems, is here. And do you have a lot of questions for 351? You want to skip 351? Do you also want to skip 760, which is the cross? You have questions. You are being serious. All right, we'll come back. We will come back and we'll try to address those questions, and we'll stop right now. So that's fine. It's 2:30. We're going to stop right now. We have plenty of other bills to vote on. Everybody's going to get a little palpitations. It is the last week. We'll be fine. But session starts at 3 o'clock. If you need to do anything prior to session, I'd do it. That concludes the voting session for today, Monday the 3rd of April, and we will see you again tomorrow.